This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about employment law. Can my boss do that? So we'll take questions on everything from wages and overtime. We will talk about safety and discrimination. What kind of privacy rights do you have while you're on the clock? How does the law define harassment? What are you experiencing? We're interested to hear. Leave off the name of your company or your boss, but call in and ask in the 31 Law Call numbers 256-536-0077. You can also email a question. You can email a legal question on any topic, any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull some out, and we've got some of your questions about, can my boss do that tonight? Getting us started tonight, Michael Timberlake's here from Timberlake & League, and you brought with you Robert Lockwood.
We brought my friend Robert Lockwood here to answer your questions because this is exactly what he does. And Robert's an old friend. He's been practicing law about the same time I have in Huntsville, over 25 years.
Old.
Then Robert has just started his new law firm. It's Lockwood & Associates. Lockwood Lawyers. Lockwood what?
So my firm's called Lockwood & Associates. Our email, well, mine is robert@lockwoodlawyers.com, and our website is www.lockwoodlawyers.com.
Well, there you go. So if you got questions about employment law, Robert does works for a number of large employers in the city and provides them consultation and information about how to handle HR matters. And he also does some work for the county commission and a number of other insurance companies in town.
And getting us started. Before we get into taking your questions about can my boss do that, we've got some video for you. We like for you to make the law call. Okay, we pulled this off of YouTube. This guy is extremely lucky. So he's shopping, looks like he's at a convenience store. Somewhere out on the road, a driver's having some trouble and is headed this direction. It's just, if it were just by a couple of inches more, whoa, look at that, it is so close. He's fine.
A lottery ticket?
Oh, he should have bought a lottery ticket this day. It's so close. I can't believe that. Okay, Michael, you guys do personal injury cases all the time.
Absolutely.
So if he had been hit, thank goodness he's not. He may be scared to death, and maybe there's some compensation for that. But if he had been hit, is there any way that the store is liable for something like that?
I mean, you're really looking at a situation where that this is a one-off type of event where, obviously a reckless driver just blew through the store. So I don't think it's something you could blame the premises owner on. It's not necessarily foreseeable that some person in a car would drive through that far into the store and hurt somebody. So I think the store's off the hook, the driver's in trouble.
Yeah.
But thank goodness it didn't look like he was injured.
Yeah. Okay, we're taking your calls and questions tonight. Can my boss do that? We're talking about employment law. Robert, walk us through. So, state of Alabama, what can bosses do and what can they not do?
So the basic thing you need to know about employment law in Alabama is we're what's called an employment at will state. That means that if you don't have an employment contract with your employer, you can quit at a moment's notice. Your employer can fire you at a moment's notice. It's at each other's will. And as a result, that gives employers a lot of discretion on how they treat their employees. Employers, you ought to be treating your employees kindly in this environment, right? It's a tough labor market. We need to be keeping our employees in shape. But the fact of the matter is, absent generally some federal law, it's going to be difficult for employees in a lot of situations to really have a lot of protected rights.
Okay, compare Alabama to Tennessee. You don't practice in Tennessee, right? Is Alabama unusual in the way things are going? Because we've got a caller that's calling in from Manchester, Tennessee. Carlene, thanks for calling in. What's your question tonight? We'll see if we can answer it for Tennessee, or we can at least get you talking about what maybe you work in Alabama. What's happening with your boss, Carlene?
Well, my question tonight is, can your employer fire you for something that you're doing off the clock?
Okay.
Ooh, that's a good question.
Give us without giving away exactly what's going on, give us an idea. What's happening?
I'm not really sure. I just
You're just wondering about, in general.
So like if you're at a bar on the lake on the weekend or something, and you're up there having a good time, and somebody posts on social media, can your boss use that against you down the road?
So let's talk about Tennessee. Let's talk about Alabama.
Okay.
All right. So Tennessee generally is pretty similar to Alabama with regard to the way their employment system works. Right. It's also employment will. generally. They've got a few more protections, but I don't know of anything in Tennessee that would really be different than what Alabama would do in this situation, which is, again, there's not really a federally protected right in what you do off the job. So if you do something, even off the clock, that your employer disapproves of, under that employment at will relationship, your employer can basically terminate you for anything they want to. The standard is what's called a good reason, a bad reason, or no reason at all. That can be the basis for termination. So sometimes it really does stink that you're getting fired at something you're not even at the employment place, but it is legal generally under Alabama law.
So you don't even have to be doing something illegal. You're driving drunk or you're charged with a crime. It doesn't have to be anything like that. You're doing something they don't approve of for whatever reason.
Right. They can let you go. That's the one thing is that they don't have to. Your employers don't have to give you a reason in Alabama to terminate you. They just call you in. They say, hey, this is it. We're going to let you go. They pay you up for the wages that they owe you at that point in time and any potential accrued benefits, and then you're on the street. So there's you don't have a whole lot of protection in that situation unless it's a protected class. So what is a protected class?
So this is now where you're starting to get into federal employment law. So federal law trumps the employment at will nature of Alabama law, and that's where protected classes come in. So generally we're talking about things like race, gender, age, disability. You can't be discriminated against because of your religion. Those are all protected classes that federal law will give you some rights in.
Right. So if you're in a protected class and you get terminated and your employer doesn't give you a reason at all, how do you prove your case if they don't say, hey, I fired you because you're from Iraq or Iran or from somewhere else in the world?
So generally there's two ways that you can go about doing that. So the first is what we call direct evidence, right? So let's use your example of Iraq. If your employer has repeatedly said, frankly, anti-Iraqi statements that have talked poorly about Iraqis, about you as an Iraqi citizen, or a woman, or somebody of a different race, then those can be protected, and that can be what we call direct evidence of a discriminatory reason for termination. That's one.
Right.
Your other way that you go about proving is what we call circumstantial evidence of discrimination. That is, let's say they don't give a reason. Well, you can show I'm the only African American employee in this workplace. I'm the only person they fired. They retained all the white people. Well, that's generally what we call a prima facie case of discrimination. It's not direct. They didn't directly mention your race, but circumstantially, when you're the only person in that class that gets fired, that's evidence of discrimination.
Yeah, so it's like circumstantial evidence or direct evidence.
Correct.
All right, cool.
Okay. We've got callers waiting. Is it Michael from Florence is next? Michael, thanks for calling. What's your question tonight?
Ma'am?
Yes. Hi, Michael. Thanks for calling. What's your question tonight?
Yes, my question is, I know that Alabama is at will state, but can your employer terminate you while you're on medical leave?
Oh, interesting.
Yeah, that is
Okay.
a good question. So, it's a little bit of a convoluted thing. So there's first thing that I'll let you talk about is kind of like the Family Medical Leave Act that applies to some employers, but there's some exceptions if you're on comp, right?
That's right. So Family Medical Leave Act applies to employers with 50 or more employees generally. So if you're a smaller employer and you're out on medical leave, you might not be protected by the Family Medical Leave Act. But generally 50 or more, then it's going to be very difficult for your employer to fire you while you're out on leave for a serious health condition. But you're right, there's also the issue of folks who get injured on the job go out on leave all the time. And what happens if one of those get fired?
Yeah, I mean, you've got some protection under the Workers' Compensation Act. If you're getting paid for being out of work and unable to do your job, your employer is going to be in a bad situation if they terminate you. So, you do have some protection in that regard, as long as the doctor says you're unable to work as a result of your injury.
Okay. They're telling us take a break. We're going to take a break. Be right back answering more of your questions about can my boss do that? If you're on the line, stay on the line. We'll be right back.
watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviat. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviat. Tonight we're taking your calls and questions about, can my boss do that? We're talking about employment law. We've got with us Michael Timberlake from Timberlake and League, and we've got Robert Lockwood, who is an employment law specialist. That's what he does all the time, so happy to hear your questions. And we've got some folks on the line. Before we get to that, there's a special event that's coming up, the Race for Justice. Michael, tell us about what Race for Justice is.
Yeah, we're both of us support the Alabama Madison County Volunteer Lawyer Program that basically assigns private practice lawyers to help people in civil seats. You're entitled to a lawyer. The state will hire you a lawyer if you can't afford one in a criminal action. But if you can't afford an action in a civil lawsuit, then Madison County Volunteer Lawyers will hook you up with somebody that will donate their time to help you in the right type of cases. They've got a big fundraiser coming up. If you're a runner, they've got the Race for Justice. This is coming up Labor Day weekend. You can hit the QR code, sign up, and I think there's still t-shirts available with registrations. You can go 5K, 10K both, or you don't have to run. Just register and don't show up.
Get a t-shirt and don't have to run at all. We've got callers waiting. Remy, thank you for waiting. Remy's calling from Florence. Hi, Remy. What's your question tonight?
Hi, Sharon. Thank you for taking my call.
Sure.
I was a federal employee and I was injured on the job, and then I was unable to come back because of my injury. And so I went ahead and filed for retirement. And when I went to get my retirement, I was quoted a certain monthly amount for my federal retirement fund. And then when I got it, it was less. So I contacted them, and they said, well, we didn't give you your credit for your 3.5 years of service time in the military. And I said, well, that's part of my retirement. You show that as my retirement date for the 30 years was the 3.5 years.
Yeah.
And they said, yeah. And they said, but we don't have any proof that you paid for your military time for your retirement. And I said, I paid for that back in 1990. And so I dug around and I managed to find a copy of their form, and they asked me whether I wanted to pay it in increments or pay it in one lump sum, and I had checked one lump sum, and the amount was, I don't know, $350 or something, and I paid it, and I put the check number on the copy. So I sent it to them. A month or so later, I get the thing back, and they said, well, we really need a copy of the canceled check.
Okay.
I said, after 30 friggin' years, you expect me to have a canceled check?
Okay.
Yeah, I mean,
what can you do with that?
You know, it's the federal government, so I'm sure it's an administrative proceeding, and there's not a whole lot of legal action you can take here, right?
That's right. So I don't represent folks in that federal process, so I can't tell you for sure, but I will tell you this. The feds love their administrative nightmares. They want to wrap you in red tape. So the key is pay attention to all the fine print that they give you in this process. There are going to be specific deadlines, particularly for appeals. There's generally 2 or 3 levels of appeal that you can follow in this thing. What they want you to do is get frustrated and just give up. Instead, really pay attention to the details, pay attention to the fine print, meet all the deadlines, and keep filing your appeals. And that's going to be your best chance to try and get some relief out of this.
Yeah, and you may, there's some national firms that do federal workers' compensation law nationally and not necessarily locally, and that may be a good place to start with your injury claim to make sure that you got what you're entitled to there as well.
Boy, that's tough. Trying to find a
Absolutely.
check 30 years ago. Remy, good luck with it. We've got Nicholas on the line with a question from Huntsville. Hi, Nicholas. Thanks for calling. What's your question tonight?
Yeah, thanks for taking my call.
Sure.
I've been with my company currently for about 15 years.
Okay.
For the last 12 years, I keep getting told I'm going to be taking over the business. I've had a life insurance policy taken out on the owner, for me to take over the business, basically being strung along and now being told I'm not going to be taking over the business.
Wow. Okay. How big a company? Wouldn't that matter how big this company is? Is it just like a one-man?
It's there's 4 employees, but we have probably about 1,600 customers.
Wow. Okay.
Right.
Okay.
Well, I mean, it really kind of comes down to, you know, what's binding in this situation. You know, if somebody's made your representation that they don't go through with, is that something you can make them do?
So, without more details, I think it's going to be tough. This is probably actually more in Michael's ballpark than mine, because Michael does a great job representing folks who've been defrauded, right? And I think if you're looking at anything here, that's going to be your best claim, which is, has a material representation been made to you that you relied on to your detriment, took certain actions, and you've been damaged as a result? I think that's probably going to be the best claim. What do you think about that?
Yeah, I mean, I think that's, you're kind of looking at what we're talking about is promissory fraud, which means somebody promised they were going to do something and they didn't end up doing it. Can you get damages as a result of that? The law in Alabama is pretty tight on that. It scrutinizes it heavily. You've got to really show that at the time that they made these representations, that they never really intended to go through with them, and not that they changed their mind. So that's may sound like it'd be a difficult thing in your situation, and that's why we tell people, if there's some kind of transition agreement, you need to have that in writing. If there's a business plan that you're going to rely on, you need to have that in writing, because otherwise somebody can just change their mind, and unless you can prove that they never intended to go through with their promises, you're really out of luck.
That stinks. He's been working there 15 years and been expecting this 12, did he say?
Sure.
Yep.
Good luck with it, Michael. Sorry to hear that you're going through that. Let's give you another one of the email questions. So we got an email question from James. James wrote in and said, if I have a cell phone provided by my employer, does that mean the company's got the right to monitor my personal calls and texts and any pictures I take with the phone? All right, Robert, they give you a phone. What can they do with it?
Anything they want.
Really?
It's their property. In the same way that you could take your kid's phone and look at it at any time.
Okay.
It might seem like a little bit of a harsh analogy, but that's the fact of the matter is. I mean, it is the employer's property. They have the right to monitor anything that happens with their property. They have the right to monitor communications coming in and out. And that applies not only to your cell phone, it also applies to your emails coming in and out using their Wi-Fi service. If you do that, they've got the right to monitor that. So just because it might seem like it's private to you, if you're doing it on your employer's property, they have the right to access it at any time.
Would they have the right to track the phone and see where you are or where you're taking the phone?
Absolutely. Again, it belongs to them. So if you're taking breaks you shouldn't be taking, if you're going places you shouldn't be going, be careful if you have your employer's cell phone in your pocket at the time. If they get suspicious, I can't actually note that I've ever had one of my clients track somebody like that, but in today's age, it can easily be done, and it certainly wouldn't be a violation of any rights that I know of.
Talk to us a little bit about hostile work environment. You say a lot of folks come to you saying it's a hostile work environment, let's sue. What can you do? What can you not do?
This is one of the most misunderstood areas of law. I mean, everybody hears the term in the public nowadays, hostile work environment. I must be able to sue because my environment's hostile. Unfortunately, that's not the case. We talked a little bit earlier about protected classes. If your environment is hostile because of that protected class, if you've been sexually harassed, racially harassed, those factors are protected. But if it's just your boss is a jerk, unfortunately, you can't sue somebody for that. Your option then is to use the employment at will statute to your advantage, right?
Just quit.
Quit, leave. You don't have to give 2 weeks notice. If this guy's a jerk, get rid of him. You're done with him. Move along.
Yeah, unfortunately, it's like, you know, being a jerk is not illegal, and there's no repercussions. So you just have to find somebody that you can work for.
Okay, talk about free speech. Do we not have, it's America, do you not have the right to say your thoughts?
You have the right to say whatever you want to, and your employer has the right to
fire you in a moment's notice. Yeah, all right, so this is another one, right? Everybody's grown up. We all learned in grade school, the First Amendment guarantees me freedom of speech.
Yes.
But there's a little caveat there. The First Amendment only governs what the government can do. So the government can't restrain your free speech, but your employer certainly can. He or she can control anything that goes on in that work environment. If they don't like something you said, you're not protected by free speech. You're not protected by the First Amendment. You can be fired at a moment's notice for anything you say on the job.
Okay, what if you say it off the job? Are you protected with that?
Okay, and actually, that's actually a great point, Sharon, and I probably should have given a little bit of a caveat. It's not anything you say on the job. So, for example, the same federal statutes that prohibit discrimination also prohibit retaliation. So if you complain about racial discrimination in the workplace, if that's what you're talking about, if you complain about harassment in the workplace, racial harassment, sexual harassment in the workplace, that's protected. You can't be fired for that.
Okay.
And also union activity, if you're lobbying for better wages in the workplace, that's probably protected. It's called protected concerted activity. The things that you say that could be designed to help the workplace are probably protected. But if it's just like the example I always give, we're Alabama fans in the Lockwood household. You know, if somebody yells War Eagle at me in the workplace, I can fire them for that. It's not protected. So whether it's on the job, off the job, not all speech is protected.
Okay. How about political stuff? If you're saying off the job, you're supporting a different candidate than they like, can they fire you for that?
Again, if it's a private employer, not a governmental entity, not like the city council or the county commission, those folks are governed by free speech in the First Amendment, and that would be prohibited under the First Amendment. But otherwise, if you're a Republican and you don't like Democrats, if you're a Democrat and you don't like Republicans, those are perfectly valid grounds in Alabama for an employer to make an employment decision.
It doesn't seem like there's a whole lot protected there.
They're very employers without a contract. Employers really have the right to control most every situation, unless it's overt like sexual harassment, racial harassment, discrimination for one of these protected classes.
Okay, we're going to take a break. Be right back answering more of your questions. Can my boss do that? Stay with us. If you haven't gotten your questions answered tonight, here's how to get in touch with Robert Lockwood with Lockwood & Associates in Huntsville, but he'll take a case all over North Alabama, 256-400-4522. Also check out lockwoodlawyers.com.
And Robert's got a great blog, so remember, if you're an employer, he's got a great blog. Look at that.
Excellent. Michael Timberlake with Timberlake & League in Huntsville. They are personal injury attorneys, so everything from car accidents to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And Sharon does family law right here in Huntsville, child support, child custody, divorce. 256-539-7337 or SharonFamilyLaw.com.
Thank you. Thank you for all your calls and questions tonight. Everybody stay safe. Don't put up with a bad boss. You've learned your rights tonight.
Find a good spot.